Good evening, class. Our topic for tonight will be Title 12 of the Revised Corporation Code of the Philippines. We will be talking about closed corporations. Our source materials, again, are Partnerships and Private Corporations by De Leon and De Leon Jr. and also the Revised Corporation Code of the Philippines, a short introduction by Aquino and Aquino. So let's begin with the definition of a closed corporation. So a closed corporation is one wherein the stock is held in a few hands or in a few families, and which stock is not at all or only rarely dealt in buying and selling. Meaning, remember, in a stock corporation, there are only a few stockholders. So the stock is contained within a few families. And remember, yung stock, shares of stock in a closed corporation, madalang lang i-deal sa buying and selling. So, madalang kang makakabili ng shares of stock in a closed corporation, and also madalang lang ang nagbebenta ng shares sa isang closed corporation if ever na they will sell yung kanilang shares of stock. So, madalang ang transactions involving ownership, transfer of ownership of shares within a closed corporation. So, remember also the mandatory provisions in the Articles of Incorporation. These are mandatory because in addition to all the items provided for in Section 13 of the Revised Corporation Code, idadagdag pa natin ito. So remember, in Section 13, yung mga items na yun yung mga kailangan yung i-include sa Articles of Incorporation. In addition to all of that, you have to include these three provisions so that your corporation can be considered a closed corporation within the meaning of the law. So what are the additional provisions? Number 1, all issued stock exclusive of treasury shares shall be held of record by not more than a specified number of persons not exceeding 20. So if the specified number of persons is 15, lagay nyo as long as it does not exceed 20. So ilalagay nyo lang doon. Ito lang ang number of stockholders namin, 20. 15, 18, etc., etc. So, there is a restriction on the number of stockholders. What else? All its issued stock shall be subject to one or more restrictions on transfer permitted by the code. So, remember, yung shares of stock sa isang closed corporation, meron siyang restrictions sa transfer. Hindi pwedeng basta-basta na lang ibenta, hindi pwedeng basta-basta na lang bilhin ng kung sino-sino. So remember, we will discuss this more when we go to Section 97. So kailangan ilagay nyo yung mga restrictions sa transfer ng shares of stock doon sa Articles of Incorporation. Also include any of its stock shall not be listed in any stock exchange or offered to the public. So there must be a provision also in the articles na yung shares of stock hindi ililista sa stock market or offered to the public. Remember, absent any of this provision, all three features provided in this section must be present, or else the corporation will not be classified as a closed corporation within the meaning of the Revised Corporation Code. So, non-compliance with the requirements shall not make the corporation a closed corporation even if the stockholders do not exceed 20. It does not matter. If you did not comply with the mandatory provisions in Section 95, hindi pa rin considered na closed corporation yan, even if the stock is held in a few hands or in a few families. So, yun ang kailangan yung tandaan. What else? In case one of the stockholders of a closed corporation is another corporation, and this other corporation owns 2/3 of the voting rights doon sa supposedly closed corporation, and yung other corporation does not fall within the definition of a closed corporation, meaning itong other corporation na to is actually an open corporation. Yung closed corporation mo sana, hindi na siya closed corporation. It is no longer covered by this provision, by the title on closed corporation. So, if the ownership in a closed corporation, yung 2/3 of the voting rights is owned by an open corporation, the closed corporation can no longer be considered as a closed corporation within the definition of Title 12 of the Revised Corporation Code of the Philippines. What else? Corporations vested with public interest are not allowed to be incorporated as closed corporations. So this will include your mining, oil companies, stock exchanges, bank, insurance companies, public utilities, and educational institutions. Not allowed to incorporate as closed corporations. What else? Also take note of the permissible provisions in the articles. pwedeng idagdag. Yung kanina sa Section 95, they are mandatory provisions. In 96, they are permissible provisions in the articles. Pwedeng idagdag nyo kung gusto nyo. Kung ayaw nyo, okay lang, walang problema. So, please take note of the permissible provisions, classifications of shares or rights, and the qualifications for owning or holding the same, and restrictions on their transfer may be stated in the Articles of Incorporation. So, remember, this is discussed more in Section 97. Mamaya i-discuss ko uli yan. Number 2, classification of directors into 2 or more classes, each of whom may be voted and elected solely by a particular class of stock. So, the example in your book, okay na yun. The directors are divided into 2 classes. Directors A will be one set is to be elected by holders of Class A shares, common Class A shares. Yung isang set naman ng directors will be elected by common Class B shares. So, pwede yun. So, you can classify yung directors into 2 or more classes, and yung mga Class A directors will be voted only by Class A shares. Yung mga Class B directors will be voted only by Class B shares. So, remember, you can classify directors, and yung mga directors as classified may be voted or elected solely by yung particular class of stock. What else? Also, you can include in the Articles of Incorporation greater quorum or voting requirements in the meetings of stockholders or directors other than those which are provided in the Revised Corporation Code. So, in the Revised Corporation Code, a meeting of directors, majority. Sa closed corporation, pwede nyong i-provide that 80%, 90% will be quorum. So, anyway, it depends on the corporation. What else? The articles may also provide that the business of the corporation shall be managed by the stockholders rather than by a board of directors. So obviously, kung ang magmamanage ng corporation is yung stockholders, yung mga stockholders na to will be deemed to be directors with all the liabilities imposed by the Revised Corporation Code upon directors. So obviously, there will be no meeting anymore to elect directors kasi nga yung mga stockholders na ang magsaserve as directors. So, what else? Yung stockholders nga will be deemed subjected to liabilities of directors because obviously, they will become the directors of the corporation. What else? Articles may likewise provide that all officers or employees or that specified officers, employees shall be elected by or appointed by the stockholders. Usually, the officers are elected by the board of directors by majority vote of the entire membership of the board. Pero in a closed corporation, they can provide that the stockholders will be will directly elect yung mga officers or employees. What else? Restrictions on the transfer of shares under Section 97. Kanina ko pa sinabing i-discuss ko ito. So anyway, remember, yung sa closed corporation, yung ownership and management is usually vested in one and the same people. Kasi nga, kukunti lang yung stockholders. Usually, sila-sila na rin ang nagmamanage ng closed corporation. Silang lahat na. Kasi nga, konti lang naman sila. So, it means that most of the or if not all of the stockholders will be tasked with the management of the corporation, and usually hindi na sila masyadong formal about it. Remember also that a closed corporation is actually an incorporated partnership. Para lang siyang partnership. But remember, as to third persons, ang kanilang liability is as to third persons and as to the government, as to the law will treat them as a corporation. So, as amongst themselves, they will treat one another as partners. Pero the law will treat them as a corporation. Kaya sa isang closed corporation, dahil nga konti ang membership, there remains yung element ng delectus personarum or delectus personae as we have already discussed in partnership. So, meron pa rin mutual trust and confidence. Kaya nga merong conditions sa transfer ng shares. Because dahil merong mutual trust and confidence, hindi bastang ibebenta sa kung kani-kanino yung share sa isang closed corporation. They will be selective of those people who want to join yung isang closed corporation. Yung mga existing stockholder, they can be selective. So, please take note of number 1. Restrictions on the right to transfer shares must appear in the articles. Not only in the articles, also in the bylaws and also in the certificate of stock. If it does not appear on these 3, articles, bylaws, certificates of stock, yung mga restrictions na yan will not be binding on a purchaser in good faith. So, what else? Second condition that may be imposed on the transfer of shares, yung restrictions will not be more onerous than granting the existing stockholders or the corporation the option to purchase the shares of the transferring stockholders within such reasonable terms, conditions, or period as stated therein. So, ibig sabihin, ang condition na pwede nilang i-impose is that the stockholder, existing stockholder or the corporation will have the option to purchase the shares of the transferring stockholder. Hindi pwedeng mas mabigat pa doon ang restriction. And number 1, the restrictions must also appear in the articles, bylaws, and certificate of stock. So in relation to number 2, please take note of the right of first refusal. So discuss muna natin to. So, the need for stock transfer restrictions in closed corporation will prevent yung changes in the control of the corporation, especially kung merong stranger na papasok doon sa corporation. So, also, dahil nga ito ay corporation na, hindi katulad ng partnership, may mamatay, dissolve. Ito dahil corporation siya, continuous yung kanyang juridical personality even if there are already dead shareholders. So, what else? Number 2, maintain the electus personae of a partnership, as I have already discussed a while ago. So, please take note, ito na, of the right of first refusal. Stockholder who wants to sell his shares must first offer it either to the corporation or to other existing stockholder. Offer mo muna sa corporation or dun sa mga existing stockholders sa closed corporation. And if yung corporation or the existing stockholder will fail to exercise the option within the period stated, the transferring stockholder may sell his shares to any third person. So that is the right granted to your stockholder who wants to sell his shares in a closed corporation. So remember, class, that the period of 1 month is deemed sufficient for the corporation or the stockholder to signify yung kanilang intention to buy the shares of stock being offered for sale by any stockholder. So, yun ang tandaan nyo, 1 month. What else? Qualifying conditions in the issuance of shares. So, yung certificate of stock must conspicuously show also the qualifications of persons entitled to be holders of record of the shares. So, sa madaling sabi, ilagay nyo sa certificate of stock kung sino ang pwedeng magmay-ari niyan. Kung halimbawa, ang pwede lang magmay-ari niyan, dapat kamag-anak ng mga Ayala. Yan. Kung hindi ka Ayala, obviously, wala ang karapatan. And this restriction or qualification must appear doon sa holder ng certificate of stock. So, ay doon sa, hindi sa holder, doon sa mismong certificate of stock, it must appear therein. So, kung halimbawa, ang qualification nyo is must be a graduate of Ateneo, etc. Ganyan. So, kung wala yon, I'm not affiliated with Ateneo class, obviously. Kailangan ilagay yung ganung klase ng qualification dun sa certificate of stock. What else? The articles of incorporation must also state the number of persons who are entitled to be stockholders, and also the certificate of stock must conspicuously state such number. Yung articles, kailangan ilagay niya 10 stockholders. Yun lang. Certificate of stock, lagay 10 stockholders. Yun din. Kailangan ilagay yan. So, What else? Number 3, stock certificate conspicuously shows a restriction on the transfer of the corporation stock. So, ilalagay din dyan kung ano yung mga restrictions. Bawal ibenta, kailangan merong right of first refusal, etc. etc. So, ilalagay nyo yan sa certificate of stock. So, these are qualifying conditions. Now, what if, class, there are breaches of qualifying conditions? Ibig sabihin, merong violation. So, in the 3 cases I have just mentioned, the transferee is conclusively presumed to have notice of the restriction, and he is not allowed to prove lack of notice even if such is the fact. So, obviously, dahil nga nag-a-appear yung qualification, nakalagay doon, dapat ang apelyido mo ay Ayala, kamag-anak ka ng mga Ayala. Ikaw naman, alam mo namang hindi ka Ayala eh, pero binili mo pa rin. Remember, it is shown clearly and conspicuously. Obvious eh, halata, nandun sa certificate of stock, nakita mo na, binasa mo na, tapos binili mo pa rin. So, yung purchase mo is in breach of the qualifying condition. May qualifying condition eh. Ito yung nakalagay, Ayala ka, hindi ka Ayala, hindi ka qualified. Pero alam mo nang hindi ka qualified, kitang-kita na based on the certificate of stock that you are not qualified, binili mo pa rin. So, this is a breach of or a violation of the qualifying conditions. Now, even if hindi mo alam, let us say, hindi ka marunong magbasa, hindi mo talaga naiintindihan, etc., etc., hindi mo na malabo yung mata mo, hindi mo nabasa yung certificate of stock, hindi mo nakita yung qualification doon, or masyadong maliit yung pagkakasulat, etc., etc., ang dami mong excuses. But remember, there is conclusive presumption na nabasa mo yun at alam mo yung qualifying condition. So, same is true with paragraph B, nakalagay doon na 10 lang ang stockholders. Pero pagka binili mo yon, shares na yon, ikaw na yung pang 11. Let us say, one stockholder, binenta niya yung ibang shares niya, pero hindi niya binenta lahat. So, magiging pang 11 ka. Nasa articles naman na 10 lang. Tapos, nasa certificate of stock na 10 lang. Tapos, alam mo, pang 11 ka. Remember, class, there is conclusive presumption that you are aware na binibreach mo yung qualifying condition. So, you are not allowed to prove lack of notice even if it is the fact. And also, remember here that the corporation cannot be compelled to register, although pwede naman kung gusto niya the transfer of stock in the name of the transferee. Because remember here, the transfer of stock is in violation of the qualifying conditions which I have already discussed in A, B, and C a while ago. What else? Number 2, transfer shall be binding upon the corporation even if there is this conclusive presumption which I have just discussed a while ago, wherein there is consent by all the stockholders, or if the closed corporation amended its articles of incorporation. So, nilagay nila sa articles nila, 11 na, hindi na 10, hindi lang 10, 11 na. So, obviously, the transfer is binding on the corporation, and also if all of them consent to such transfer. Transfer will include the term transfer will include also a donation, and remember number 4, the breach of any restriction in the issuance is without or transfer of stock is without prejudice to the right of the transferee under existing law to rescind or cancel the transaction or recover under applicable warranty, express or implied. So obviously, kung ikaw yung nakabili, tapos hindi mo mailipat sa pangalan mo, ayaw i-recognize ng corporation, syempre yung nagbenta sa'yo, may warranties yan because this is a contract of sale. So pwede mong i-claim yung applicable warranty, and also, obviously, you can cancel yung transaction with the stockholder/seller. What else? Valid agreements by stockholders under Section 99. So in Section 99, agreements signed and executed by and among all stockholders before the incorporation will continue to be effective between the stockholders even after incorporation, provided, class, that the agreements are consistent with the articles of incorporation. So there are agreements before nag-incorporate, tapos afterwards, yung mga stockholders na yan, they are still bound by the same agreement, provided that the original agreement before incorporation is not inconsistent with the articles of incorporation. What else? Written agreement signed by 2 or more stockholder to exercise voting rights as per agreement will be valid agreement. So remember, letter A will refer to any agreement by the stockholders in general before incorporation. Number 2 is letter B will refer to your voting or pooling agreements in particular. So, paano ba tayo magvo-vote? Ito ang agreement natin kung paano voting. So, that agreement will be valid between the stockholders under Section 99. What else? In addition to that, no provision in a written agreement signed by the stockholders relating to any phase of corporate affairs shall be invalidated on the ground that its effect is to make them partners among themselves. So, kung merong provision or agreement in any contract, or there is a contract between any stockholder that has the effect of making them partners as to one another, hindi ito may invalidate based solely on this ground. Because remember, again, a stock corporation, closed corporation is an incorporated partnership. So, they operate as a partnership as among themselves, pero the law treats them as a corporation. So, yun ang tandaan natin in number 3. What else? Written agreement among some or all of stockholders shall not be invalidated on the ground that it relates to the conduct of the business and affairs of the corporation as to restrict the powers of the board of directors. So, remember here in letter D, if the agreement will restrict the power of the board of directors or interfere with the power of the board of directors, hindi may invalidate yung agreement na yan. Provided class, such agreement shall impose on the stockholders who are parties thereto liabilities for managerial acts. So, they will be liable for, the liability is for managerial acts. It will be liable for managerial acts. So, remember yung number 4. And number 5, stockholders who are actively engaged in the management of the business shall be held to fiduciary duties, and they will be liable for corporate torts or quasi-delict unless there is liability insurance obtained by the corporation. So, itong mga agreement na to, remember, A, B, C, D, and E are valid agreements which may be entered into by the stockholders. Yan. What else? Actions taken without proper meeting. So, meeting is not properly called. Walang proper notice, probably hindi siya proper place, etc., etc. There is a defect in the meeting. Usually, the rule is this meeting is the meeting improperly called pagka meron tayong mga corporate actions dyan. The corporate actions are deemed void actions. But here in Section 100, valid. The exception is when otherwise provided by the bylaws. So here in Section 100, actions by the directors of a closed corporation without a properly called meeting is deemed valid in 4 instances. Yan. Number 1, before or after such action is taken, written consent is signed by all directors. So meron ng written consent before or after such action is taken. Obviously, if it is signed by all directors, there is an implied ratification of the corporate action taken at an improperly called or held meeting. What else? All the stockholders have actual or implied knowledge of the action and they make no objection to the same. So, alam nila na merong ganong klaseng action but they did not object. So, there is again implied ratification of the corporate action at an improperly called meeting. What else? Directors are accustomed to take informal action with express or implied consent of all the stockholders. Sanay sila sa bara-bara. So, sanay sila sa walang formality. So, here, remember, actions taken during an informal meeting are, again, valid corporate actions. Dahil sanay sila sa ganung style. What else? All the directors have expressed or implied knowledge of the action, and none of them makes a prompt objection thereto in writing. Remember that the objection here is in writing. Alam na nila na mayroong action in an improperly called or held meeting. They did not object promptly in writing. Remember, these corporate actions are valid due to waiver on the part of the director who actually wants to express objection pero hindi niya ginawa. So obviously, there can be no ratification if the meeting, yung action taken is beyond the powers of the corporation or ultra vires. What else? Preemptive right in closed corporations, section 101. In closed corporations, it extends to all stocks, common or preferred, voting or non-voting, newly authorized shares pursuant to an increase in the capital stock or newly issued balance of originally authorized shares. Ito yung mga hindi pa naibenta but they are original issues, and will also include treasury shares. So anyway, we have already discussed preemptive right in Title 4. So remember, sa open corporations, merong preemptive right. Sa closed corporations, obviously, meron pa ring preemptive right. So, yung preemptive right is the right, again, to be first offered shares of stock before it is offered to the public. So, pagka preemptive right ang pinag-uusapan, iba ito sa right of first refusal. Yung right of first refusal is transfer from a stockholder papunta sa ibang tao or yung corporation. Offer mo muna sa corporation or sa existing stockholder before you offer to the public. Preemptive right is a transfer from corporation to the stockholder. So whatever kind of share it is, as long as the transfer is from corporation to the stockholder, may preemptive right ang mga stockholders sa closed corporation. So matter of absolute right. The other exceptions as applicable, as provided for in Section 38 is not applicable in closed corporation. So absolute right on the part of the stockholder except when there is a provision or exception in the Articles of Incorporation. So yung mga applicable na exceptions sa Section 38, not applicable in case of closed corporation. So basta may i-issue na shares ang closed corporation, i-offer first to the existing stockholders before it is offered to others. Anyway, class, sa closed corporation naman, hindi ka pwedeng basta-basta mag-offer na lang sa third persons, especially if they are not qualified based on the qualifications set in the Articles of Incorporation. So, amendment in Section 102, the amendment here will seek to delete or remove any provision required by Section 95. So, tatanggalin mo yung isa sa tatlo, or kahit yung tatlo na mandatory provisions in Section 95, or to reduce a quorum or voting requirement stated in the articles, it will require at least 2/3 OCS, with or without voting rights or any greater proportion as is required in the Articles of Incorporation. So remember here that there must be a meeting called for the purpose. So mere written assent is not sufficient, although this is allowed under Section 15 para sa closed corporation, bawal ito. But the other provisions of Section 15 will apply. What else? Also here, sa first part, dito sa part na to, ayan, seeks to delete or remove any provision required by Section 95. The effect here is to terminate the status of the corporation as a closed corporation. Kaya nga tinanggal mo yung isa sa tatlong yon, or tinanggal mo yung tatlong yon, because your closed corporation, hindi na siya closed. Ita-terminate mo na siya, probably it will be open to the public. Kaya nga nag-amend kayo in such a way. Intra-corporate deadlocks under Section 103, meaning directors or stockholders, obviously at this point, class, na napansin nyo na siguro that closed corporations are stock corporations. Diyos ko, pagka hindi nyo pa napansin yan simula kanina. So, the applicable provisions are Title 12, suppletorily the provisions on stock corporations. Obvious naman yan. Nga ako, class, pagka, ay, ngayon nyo lang na-realize yan. Ay, nako. And I hope, class, you are updating with the videos. Baka mamaya, natatabunan na kayo, tapos, hindi nyo na malaman kung paano kayo mag-aral later on. Tapos, magre-reklamo na naman kayo kasi reklamador kayo BSA kayo So, obvious, reklamador. Alam ko na kayo. Matagal na ako nagtuturo ng mga BSA. So, anyway, in intra-corporate deadlocks, remember, stockholders are so divided respecting the management of the corporation that the votes required for any corporate action cannot be obtained. Laging tie pagka nagbotohan. Kanya nga deadlock kasi laging tie, laging deadlock. Yan. Ay, mahirap palang pagtapatin pagka hindi ka nakatingin ng mabuti. So, laging equal, laging tie. So, wala kang makuhang majority vote, wala kang makuhang required vote, hindi mo makuha yung 2/3, etc. You cannot get the required vote to transact business. So, obviously, the transactions of the business of the corporation cannot be conducted because of the deadlock. So, kung ikaw ay isang stockholder sa closed corporation na to, you can file a petition to the SEC to arbitrate the dispute. So, mamamagitan sila. So, anyway, as an arbiter, to be an arbiter is power granted to the SEC. So, even if there is a provision in the articles or bylaws or agreement of a stockholder na pinagbabawal yung arbitration by the SEC, hindi, pwede pa rin mag-arbitrate ang SEC because that is the power provided by law. Hindi siya pwedeng baguhin by agreement, by the articles, or any provision in the bylaws. So, in the exercise of the powers of the SEC, pwede siyang magbigay ng kahit na anong order which it will deem appropriate under the circumstances. And remember, it may also include dissolving the closed corporation. Now, SEC may order the dissolution, but if the business is successful, pwede naman din siyang mag-appoint ng isang provisional director as an additional member of the board. So, kung may additional member of the board, obviously, mabe-break na yung tie. Yan. Usually, nangyayari ito pagka equal sila ng shares So, yung kanilang outstanding capital stock, hindi nila makuha yung vote required. So, yun ang nangyayari dyan. And also, please take note of the matters within the competence of the SEC as an arbitrator. The SEC can cancel or alter any provision in the articles para lang at least ma-break yung deadlock. So, cancel or change any provision in the articles or any stockholders agreement. Number 2, they can also cancel, alter, or enjoin any resolution or act of the corporation, its board of directors, stockholders, or officer. So, pwede nilang i-cancel ang kahit na anong resolution, palitan, or pigilan any resolution or act of the board, etc., etc. They can also prohibit any act of the corporation or other direct or prohibit. Pwedeng pagawa nila ito, pwedeng i-prohibit nila itong bagay na ito, as long as it will serve to break the tie or to resolve yung deadlock in a closed corporation. Also, the SEC can require yung purchase at fair value yung shares of any stockholder either by the corporation regardless of availability of unrestricted retained earnings in its books or by the stockholder. Para ma-break na intay itong matigas na ulo na stockholder na to, bilhin nyo na yung shares niya. So, it can be bought by the corporation even if there are no unrestricted retained earnings. Ito yung isa sa mga exceptions. And also, by the other stockholders. Bilhin nyo na yung shares nito. Total, nanggugulo lang yan. Ayaw nang makisama, etc., etc. Just to resolve yung deadlock. What else? Like I said a while ago, appoint a provisional director. We will discuss more later on about provisional directors. Dissolve the corporation, and very important, such other relief as the circumstances may warrant. So also, a provisional director under 103, impartial person, not a stockholder, not a creditor of the corporation or of any subsidiary or affiliate, and whose further qualifications may be determined by the SEC. So, a provisional director will have all the rights and powers of a duly elected director. Director talaga siya. Meron siyang right to notice, right to vote, etc. until such time he is removed by the SEC or by all of the stockholders. May sweldo ang provisional director. Imagine mo, taga-boto ka lang, taga-break ka lang ng time, meron ka pang sweldo. So anyway, determined by agreement between him and the corporation. If the corporation and the provisional director cannot agree, SEC may fix his compensation. So anyway, yung agreement between provisional director and corporation is also subject to approval by SEC. What else? Right to withdraw, lastly, of a stockholder. So, and the stockholder can withdraw from a closed corporation for any reason. As in, kahit trip lang niya. So, now, if a stockholder will withdraw from the corporation, he can compel the corporation to purchase his shares at their fair value, which shall not be less than their par or issued value, provided that the corporation has sufficient assets in its books to cover its debts and liabilities exclusive of capital stock. So, the right to withdraw, remember, as I've said a while ago, may be exercised for any reason, provided that the corporation has sufficient assets to cover its debts and liabilities. But parang ulit lang yun. Anyway, also, any stockholder may have the any stockholder in a closed corporation has the right to petition the SEC for dissolution if there are illegal or fraudulent acts of the directors, officers, or any person in control of the corporation. If there are dishonest acts, oppressive acts, unfairly prejudicial acts to the closed corporation or any stockholder, or even if corporate assets are being misapplied or wasted. So, yung isang stockholder, kung feeling niya meron ng mismanagement, this stockholder can petition the SEC for dissolution of the closed corporation. So, obviously, there must be a legal ground and kailangan merong notice and hearing. Yan. So, SEC will order the dissolution of this closed corporation. So, anyway, class, that's it for Title 12 Closed Corporations. Please stand by again for Title 13. That will be a very long discussion. It is comprised of 3 chapters, class. So anyway, good evening, class, and thank you.